Thank you, Chair. I'm Dean Russell. I'm the Member of Parliament for Watford, and Lord Chancellor, thank you so much for joining us today. My questions are related primarily to the government plans to update the Human Rights Act. Lord Chancellor, given your background as Chair of the Conservative Human Rights Commission, you obviously sat previously on the Joint Committee of Human Rights, where we are now, and as well as your role of Lord Chancellor, I'm sure without a doubt that you recognise the important role that human rights play in protecting the most vulnerable in our society. And so I was interested in understanding from the work that you've done how the position might have changed with regards the European Convention on Human Rights and our stance and the stance from the government with regards to that, please.
Well, thank you very much indeed, Mr. Russell, and I can reassure you and indeed the whole committee of the government's continued commitment to our membership of and support for the European Convention on Human Rights. It's the 70th anniversary of its incorporation. It was British lawyers who helped lead the team. In fact, one of my predecessors, Lord Kilmuir, Sir David Maxwell Fyfe, as he then was, helped lead the drafting of this important document that resonates through the years and which enshrines fundamental rights which have been adhered to increasingly across Europe as the Council of Europe expanded to include more and more countries. And indeed, it's in that tradition of helping to enshrine rights and to protect liberties that I sit as Lord Chancellor, not just domestically, but also the international obligations that we have. And I think it's the duty of government in being the guardian of rights to make sure that they are absolutely in the right place, the right space, if you like, when it comes to our domestic law. And that's why the manifesto commitments that we made before the election, which successfully returned a Conservative government, are ones that are entirely within that tradition and entirely within the duty that I think we all have to make sure that the legislative framework is actually working in a way that helps all of us and in fact enhances the reputation and the role of human rights and civil liberties as being the bedrock, if you like, underpinning a civilized, democratic, free society.
And may I ask then, so you wrote to the committee previously saying that the government remain committed to the ECHR. If you're satisfied with the European Convention on Human Rights, why would the government consider any amends to that, and why wouldn't you just cross it over as it is to English courts right now rather than making any changes?
Well, I think there's a difference, isn't there, between the convention itself and any domestic framework that we have that helps the enforcement or application of it. And by that I mean, of course, the Human Rights Act of 1998. Prior to its coming into force some 20 years ago this year, the convention rights applied here. The question was whether or not there was an adequate domestic framework for their enforcement. It was very much felt that there wasn't, hence the coming into force of these provisions. They're now 20 years of age. I think it's absolutely within the traditions that I've just mentioned for the government to look at them again and to make sure that they are working in a way that benefits the majority of us, and that we make sure that the mechanisms are effective, that our courts feel that they are able to apply legislation and indeed to take decisions within the margin of appreciation that we all well know exists as part of the case law of the Strasbourg Court, and that we have that sense of support, widespread support, and an enhancement of the role of human rights within not just our law, but also our wider society as well. And I think it's important that we remember the context within which the government seeks to act here. It is all about enhancement and protection rather than anything that I know some commentators might interpret as some sort of attack or wish to undermine the very principles that we ourselves helped create 70 years ago.
And so, thank you for your answer. On that, though, you, in your recent letter, you stated specifically that the government is committed to updating the Human Rights Act. But I'd be really keen to understand any specific examples of how you consider the Human Rights Act to be out of date. Could you give me some specifics on that, please?
I think it's important to remember that as of course the Act bedded in, we had developing case law around it, and after 20 years, it's only sensible, I think, for us to take stock of where things have got to and to ask some questions. And any review that takes place is going to be very much an independent process of mature reflection rather than a review that has predetermined conclusions which are set by government. That's not my intention at all, and that's certainly not how any review would work. I think we can perhaps start by coming to Section 2 and the issue about the courts taking into account the jurisprudence of Strasbourg, how that particular phrase has worked, how it's been applied here domestically, whether there are issues with it. There have over the years been questions asked about that. Are we still in that same place? Is there a problem to be solved? And also then looking at the general framework in sections 3 and 4. That is the framework within which incompatibility or otherwise is determined. I think all those questions are entirely legitimate ones. I think it would not be necessary for us to revisit the rights themselves. They've been clearly set out in the Convention and then reflected to a large degree by the Human Rights Act framework itself. But what I'm more interested in is the mechanism and is the way in which the case law of Strasbourg is used and applied here in the UK. Entirely proper questions to be asked, and ones that I very much hope will occupy any review that takes place.
Thank you. If I may just clarify then, so in terms of the response you just gave, am I correct in understanding you're not seeing anything coming out during the review, perhaps only being added to it, or did I misunderstand that?
No, look, I'm not going to prejudge what the review might do or not do, what its findings might not be. But what I'm interested in is a review that looks at the mechanics of the Human Rights Act, the way in which it operates, and the way in which our domestic courts operate with the court in Strasbourg. I mean, there's been, and I'm glad to say, plenty of really good examples of judicial dialogue between domestic courts and the Strasbourg court over the last few years. That's something I strongly support. I just want to make sure that that's in a good place, whether there's more that needs to be done with respect to that. And I think asking ourselves the question about parliamentary involvement in compatibility issues. Have we got that right? Is it too much of an ex post facto situation whereby your committee and others issue important reports or declarations are made, if you like, at the doorstep of the passage of legislation rather than at the initial stages? I think those are legitimate and proper questions for us to ask. And it may well be that Parliament's role could be enhanced as a result of any deliberations and the product of any deliberations that the review conducts. So this is designed to be very much a mature reflection rather than some knee-jerk response, which I would never support or endorse, but which, as I've said, in very much in the traditions of my role as a guardian, if you like, of human rights, I want to develop things further and see how we can improve the current situation.
Thank you. And you mentioned the term examples earlier. I would just be interested to know if you could name any specific instances where you think the Human Rights Act has actually been a problem.
Well, I think we know some of the history of what we regard as some of the more difficult cases, and it doesn't take too much imagination to cast our minds back to the prisoner voting issue, which in the end, of course, was resolved through the appropriate means via the Council of Europe. But it did take some 12 years to resolve generated a huge amount of heat and controversy, and really absorbed a lot of energy, quite a lot of negative energy, it seemed to me, that then took away from, that undermined, that derogated from many of the beneficial effects of the human rights framework. I can think of the Abu Qatada case, again, a very lengthy set of proceedings which took many years to resolve. That, of course, was complicated by the fact that it involved another jurisdiction outside of the Council of Europe area. But those examples are just a few examples of how quite controversial cases with difficult subject matter can almost overwhelm the otherwise positive message that needed to be sent out about what the human rights framework can achieve. And I think it is absolutely incumbent upon me to reflect on all of that and to see whether or not there are things that we can do better in terms of the operation of our own processes, and whether or not we can make refinements and improvements.
And if I may, just a couple more questions, if that's okay with the chair. Just with regards to this review, is this it? I mean, is the review happens, anything gets implemented? Is there a case that now this is within the control of government? Are we going to see another review in 10 years, 20 years, 5 years? I mean, is it going to be an ongoing case of reviewing it, or is it going to be a one-off?
Well, the manifesto, of course, commits the government to a course of action over a parliament. And so, therefore, we are looking at a 5-year period, are we not? I can't obviously commit any future government to what it might or might not do in this area, but I think it's right to be therefore to confine myself to what we said in the manifesto and what we intend to do. And I think everybody on the committee and the wider audience can be either reassured or informed that this is all about updating, refining, improving in the light of experience. And now we've had 20 years of that experience. I think the time is right to do this.
Thank you. And very finally, just in terms of the transparency of the review and the activity and the outcomes of this, could you just explain some of the process there for me, please?
Well, of course, I'm not going to outline in detail what has not yet been announced. I can say that it will be independent, that the panel that would be created would be a diverse one and reflect, I think, most properly the fact that this is a United Kingdom issue and that therefore voices and opinions and influence from all corners are absolutely essential in order to get that balance right, and also diversity of thought. I don't want this to be some body that has a collective groupthink. I want that diversity of opinion to very much play a part in the deliberations of the review. And in time, it will, I would envisage, present a range of proposals and ideas to government, which the government would then consider in the round and develop its policy accordingly. Of course, the government won't be bound by the findings of any review, but no doubt its views and processes will carry significant weight. And without going into the detail as to timescales, as to the precise product of any review, I think that committee members can be reassured that it will be a careful process rather than government unilaterally coming up with its own ideas and proposals without thought and without consultation.
Thank you. Thank you, Lord Chancellor. Back to you, Chair.